This is a Morrisons, Solicitors and Hardwicke Chambers podcast. Welcome to Property Matters.
Hi everyone, and thank you for tuning in to this video podcast. Just a quick announcement before we proceed. After we recorded this particular podcast, there was a government announcement to extend the ban on evictions by a further period of 2 months until the 23rd of August 2020. So in this episode, when we talk about the expiry of the stay on possession proceedings, it may be that the expiry is not as imminent as we make it seem, because it's very likely that this announcement will result in an extension to the stay of possession proceedings. And if that's the case, then we at least have an answer to the final question in this podcast, which was, is there likely to be further legislative changes? Well, after this announcement, it seems highly likely that there will be an amendment to the existing legislation in order to implement that government announcement and extend the period of the stay until 23rd of August. That's it. So I hope you enjoy this podcast. Thank you.
Okay, I'm Graham Halsall. I'm a partner at Morrisons Solicitors and I specialise in property litigation.
I'm Lina Mattsson. I'm a barrister at Hardwicke Chambers. I also specialise in property litigation, and over the last 10 years I've had lots of experience in landlord and tenant disputes. And since the coronavirus and the lockdown of our court, I've had what we now call the virtual hearings. So quite a lot of experience on the ground as well.
Yeah, I'll get more of that experience than me. So you can lead the charge on that side of things, Lina. Okay, so it's possible that somebody might listen to this podcast one day, Lina. So I should explain what it is we're doing and what it's all about. The idea behind this podcast, we're looking at some of the challenges and opportunities that are facing the property industry following the lockdown, and as we emerge out of the period of inactivity in terms of court proceedings and that sort of thing, and some of the issues and challenges that flow from that. Now, as litigators, there's going to be a tendency for you and I to focus on the contentious side of things, of course, but we will try and deviate into stuff of more wider application. And if necessary, we can always call upon experts to contribute. And if anyone is listening and fancies contributing to this podcast, please get in touch by emailing me at info@morlaw.com or direct message via the social media links that this will be going out on. Okay, so in this first episode, we're going to be reflecting on some of the measures that were put in place to prevent and restrict possession proceedings. And we'll be looking at the landscape that faces us as they start to lift those restrictions and measures. So shall we start by looking at what those measures are, Lina, and just as a refresher?
Yeah, absolutely. There have been so many changes in landlord and tenant law of the last few months. It's hard to know where to start. Obviously, the biggest changes is the aptly named the Corona Act 2020. In a nutshell, what it does in the landlord and tenant context is that it provides for protection from tenants from eviction. It achieves this in a number of ways, but broadly, it prevents the court from making any possession orders. If you have a possession order, it prevents enforcement by bailiffs or sheriffs. And also, if you, in the commercial context only, the landlords are prohibited from peaceful re-entry. So numerous ways that the Corona Act is seeking to protect tenants from eviction. In the rest of the context as well, you have another layer, of course, which are the notices to quit. Ordinarily, we know we had notices which would extend between 2 weeks and 2 months. Most of these notices have now been extended to 3 months. So a long period of time for landlords to wait. It's not quite clear yet, because this act, as we can imagine, was drafted in quite a rush. It's not clear how this applies. It doesn't apply to all tenancies, we know that, but we wait to see what the courts say about construing it. I guess the word of warning to anyone watching is beware, there are new forms if you are intending to serve these notices. And as you and I know, Graham, there's nothing worse than coming to a
I've had
possession hearing
I've had
months down the line
I've had to
and
redraft.
having your case thrown out
Yes,
because you didn't serve the
yes.
correct notice. So if you are intending to serve, get some advice. And if you are being served with one, again, get some advice.
Yeah.
There might be lots of challenges to these notices.
Yeah, it's an area where technicalities matter, unfortunately, and
indeed, we love taking technical points in litigation.
Absolutely. Yes. Good. Thanks, Lina. There's also, obviously that was the big one. The other big measure was the moratorium, the stay on possession proceedings, implemented by Practice Direction 51Z, pursuant to the CPR rules, the court procedure rules. I'm just to explain what that is, and as a reminder, I'm going to try some IT skills here and share the government announcements which preceded that legislation, so bear with me. Okay, so it started with, hopefully you can see that, Lina?
Yes, I can see it.
Excellent.
Yeah.
Right. So the reason I'm sharing this is because this was the first announcement that you can see here. I'm highlighting 18th of March, and the announcement was a complete ban on evictions and additional protection for renters. And then further details are provided down here. Not going to read that out, but you can just going to highlight related to private rented accommodation, social or private rented accommodation, and it refers specifically to buy-to-let mortgages. So initially, no mention of commercial properties. That came a few days later, and again, let me see if I can share that. Is that showing up? Is that showing up at your end?
Indeed it is, yes.
Excellent. Okay, and this was on the 23rd of March, an announcement. Here are the details. And it says commercial tenants unable to pay rent because of coronavirus will be protected from eviction, and various other things here, which again, I'm not going to read out, but it basically had the same approach to residential tenants to offer them protection from eviction during the course of, or as a result of, the coronavirus spread. Now that led to the practice direction that I mentioned a moment ago, practice direction 51Z. And again, I'm showing that on the screen. Hopefully you can see that. It's a short piece of procedural rules. And I'm just going to highlight the key provision, which says that all proceedings for possession brought under CPR Part 55 and all proceedings seeking to enforce an order for possession by a writ or warrant of possession are stayed for a period of 90 days from when this direction comes into force. So I should just explain what a stay is, because it's not obvious to everybody, especially those who are not involved in litigation. The best way to think about a stay is it freezes everything for a moment in time. It's down tools for everything. Nothing goes away, nothing's supposed to be affected in terms of the court process, but it's literally like pressing pause on all proceedings. And in this case, they've pressed pause for 90 days. And that applies to evictions and possession proceedings for residential as well as commercial proceedings. I'm just going to stop the screen share from just now. Just going to pause it a second, Lina.
Yeah.
Okay, so that was the key effect of that, was to pause all possession proceedings that were ongoing and going through the courts, meaning that landlords and tenants could not materially progress their claims. And that was a reaction to the government announcement. But that refers to existing claims. I should point out that it also refers to new claims, in the sense that you can still issue, that means start a claim, but once you start it, it's automatically caught by the stay. The reason why I want to mention this is because you should not wait till the end of the stay to issue a claim. There's no reason why you would. You don't gain any time by waiting. But it also occurs to me, Lina, that limitation periods could be relevant here. you mentioned notices earlier, of course, and a Section 21 notice has an expiry period of 6 months, I think it is, from the date of service within which you have to bring proceedings. If you don't, that claim is time barred. And the other one that occurred to me, of course, is adverse possession claims against you. If you want to prevent those claims from accumulating the relevant period of occupation, you have to bring possession proceedings. So the one thing I wanted to say about that was there is still a real need to issue proceedings, even though you'll automatically be caught by the stay. So that's that point.
I agree with you, Graham. Go on. Sorry. I was going to say, I absolutely agree with you. Yes, there's a stay, but litigants should be very careful of sitting on their hands, because a limitation is not going to be affected. There's nothing in 51Z which is going to prevent you from issuing. So the court, I like to have regard for that when it comes to delay. We shall see. I mean, the interesting part, of course, for us lawyers is that we don't know how the court is going to approach, for example, the question of delays and failure to comply with directions and so on and so forth during this time, because, of course, not everything is stayed, but many people have not been able to go to work. So one would expect some sympathy from the court, and the new guidelines is that the court should take into account any delays or breaches of court orders. And that's been happening because of the coronavirus. But yeah, it's a wait and see, I guess. We all look forward to litigate these points in due time and due course.
Well, it's interesting you say about the directive on being sympathetic towards delay, because one area where there's no room for sympathy, and that's deadlines and limitation. If you miss those deadlines, I can't see them the courts being sympathetic. Their hands are tied, really, aren't they? I mean,
yes, there is no jurisdiction indeed, because it's by statute. But of course, the limitations are quite long. I mean, you would have had 6 years by the time most limitation periods run out. So yes, have you sat on your hands for that long? The court is unlikely to be that sympathetic, because you've had 90 days stay.
Yeah, it's very true, of course. And the other thing I think I'm right in saying is service of claims is unaffected by the stay. Again, we should explain, once you've issued, you get 4 months to serve. And now I'm saying 4 months. I'm looking at you, Lina. That is correct, isn't it?
Yes.
4 months.
4 months, but outside of jurisdiction is 6 months.
That's where I was blanking. That's unaffected. That's right, isn't it? Yeah, so that's one area where we can relax. Just finally, before I move on, there's some exceptions to Practice Direction 51C. Those actually got brought in later on, because after the initial drafting of the Practice Direction, it was pointed out that it gave trespassers the ability to occupy land without any kind of ability to remove them through possession proceedings for the entire stay period. So they brought in an amendment which meant that the stay does not apply to trespassers. But not all trespassers.
Indeed, it's important to remember.
You were the one that brought it to my attention. So go on, you explain.
It's very convoluted drafting on part of the draftmen, but 51Z does only apply to persons unknown. So if it's a trespasser, but you happen to know the person's name, you can't avail yourself of the exception in 51Z, which seems somewhat unfair. That said, in my experience, and I've had 2 of these cases now, the court will happily grant you an injunction against a trespasser. They will say, as a proprietor of land, you have a right to exclude trespassers. So we can't give you a possession order, but we can give you an order that they have to vacate the land. And that has certainly been, in my experience, the way that the court got around the stay, which otherwise seems pretty unfair on owners who have to tolerate trespassers.
Yeah, I mean, I agree. That cannot have been the intention of the drafting, that you're only allowed to remove a trespasser if you do not know their name. It just makes no sense. I mean, trespasser is a trespasser.
Indeed, but I guess what they try to catch is the fact that you have trespassers who have had notice to quit, which has expired, but they might have been tenants for many years. In law, they're trespassers. But in reality, they've been tenants and deserve protections like everyone else. So I guess it's that delicate balance between the drafting against trespassers who are, as we think of them, people who come onto your land and
squatters.
squatters indeed,
Yeah.
and the people who have been tenants in the past but had notice to quit expire.
Okay, good.
What do you think is going to be the biggest challenges now facing landlords and tenants once this moratorium has been lifted on the 30th of June?
Okay, so lots of challenges for sure. The one that springs to mind firstly is one that mainly concerns commercial tenants. Now, the stay/moratorium, that started just after a quarter day and it will end just before the next quarter day. So that may have been intentional, may have just been luck, but it means that there may not have been a build-up of rent arrears for those tenants that pay quarterly. But by the same token, a lot of these tenants won't have been generating any work, and they'll be having this quarter day will be coming, and then the next day they'll be facing the potential for eviction proceedings. If they can't pay the rent on the quarter day, or if they're a tenant that pays monthly and hasn't been paying its rent during the last 3 months by the time it's lifted, they will be exposed to a number of risks. Principle of which, for me, I think is the right for the landlord to forfeit the tenancy, and especially by re-entry. Now, I just want to explain what forfeiture is to those listening. Very simply, forfeiture just describes the process by which a lease can be brought to an end on the count of some breach of covenant or condition in the lease. Forfeiture can be remedied by another process called applying for relief from forfeiture, but it's a very direct way of terminating the lease in circumstances of the breach. And forfeiture can be effected in one of 2 ways: one by the issuing of court proceedings, and the other by what's called peaceable re-entry. And Lina, you mentioned that peaceable re-entry has been caught up by the coronavirus. So landlords, well, only on non-payment of rent, I should say. But it was provided for as part of this package of protection whereby landlords could not effect forfeiture by re-entry during the 3 months. Now, I mention this specifically because I don't think tenants generally, commercial tenants, appreciate how exposed they are to re-entry by forfeiture by peaceable re-entry. It's a very simple and cost-effective way of forfeiting the lease, and one that can be done summarily without a court order. And so tenants who have been unable to pay their rent or are thinking of not paying their rent on the next quarter day, they could find themselves in a very difficult position whereby the landlord is able to seek possession very easily and quickly and cheaply. And to recover possession for the tenant, they're in a very different position. They have to get a court order, technically, to get back into the premises. So that's one of the reasons why I think this is something that needs to be considered for tenants, because they could find themselves in a difficult position come the expiry of the moratorium.
I agree with you, Graham. I think tenants who haven't been paying their rent are really going to struggle to, well, protect themselves against landlords who really want them out once this moratorium is lifted. I think something else to mention in respect to the Corona Act is ordinarily as a tenant, you have the protection of an old doctrine called the doctrine of waiver, which means that landlords often mess up and do something once they had a right to forfeit, which is called waiving the right to forfeit. So they do something that confirms that the lease is ongoing. Again, it's another technical point that us lawyers like taking, but it's a very good protection for tenants very often, because you can run this as a defense even if you haven't paid your rent or you are otherwise in breach of your lease. That, in respect of non-payment of rent, has been varied, the common law, by the Corona Act 2020. So nothing that the landlord will have done between 26th of March and the 30th of June can waive its right, or the landlord's right to forfeit. So this is another layer of protection that's been removed in proceedings. Yeah. So we do have to look out.
Yeah, just a really good point, actually, Lina, because waiver, as you know, can trip up landlords with an inadvertent waiver of forfeiture. Innocently, they can waive that right of forfeiture. What they have been given, effectively, is a clean slate, because nothing they've done in the last 3 months by the time this is lifted will count as waiver. I think that's right. And
that's right. I mean, in one sense, it makes sense because it means that landlord can negotiate with tenants, which they otherwise couldn't do about rent reductions. Yeah.
Well, no, it makes sense, but they've been given this clean slate that they wouldn't normally have. You know, certainly when a landlord comes to me and I'm presenting the options to them, we go over this, have you waived forfeiture? Once you explain what it is, quite often they have, innocently, just by doing what you've said, by trying to be a good landlord and speaking with their tenant. But it's one of the, it's about, the question was about challenges, and I see this, and these measures have all been about the balancing the two parties, landlords and tenants. And I think this is one area which I think the tenants are really at a disadvantage when it comes to the lifting of the stay for a number of reasons, including this.
Yeah, absolutely. I think it's one of these elephant traps for tenants to look out for, not thinking that they can sit tight and the landlord can't re-enter. Of course, something that you always have to do. If there hasn't been payment of the March quarter rent, then it's likely the landlord will have a right to forfeit under the lease. But it's also, if you haven't got your June quarter rent, it doesn't mean that you automatically have a right to forfeit straight away. Yeah. Very often the lease will provide that you need to wait for often 21 days. So that means mid of July. Yeah. So even though landlords will be rearing to go and really want to kick tenants out.
That's okay.
I was going to say, trying to mute there. People in the background absolutely not wanting to pay their rent.
We did say there'd be guest contributors. We now have our first contributor.
Indeed, a stubborn little lady.
Anyway, sorry.
Yes, no, so I think, as we were saying, always check your lease. It's a must in any litigation with tenants.
That's a very good point. It's a very good point. And the point you make about landlords rearing to go, that's an interesting one as well, because I have had a lot of inquiries from clients and prospective clients who are, I get the sense they're rearing to go, okay? Because maybe they feel that their tenants have taken advantage of the situation. I'm sure that may be true in some cases. So you do have this perfect storm. You've got this build-up of potentially rent arrears if it's monthly, and the impatient landlord, and this it could just lead to this explosive environment. But on the other hand, who wants to have empty premises at in this market? You know, it's a brave landlord or a confident landlord that wants to kick out a tenant in these conditions. So there's that to think about as well.
Absolutely, and particularly if you have a tenant with semi-good covenants, the rents are now likely to fall in the future. So you may not want to have to grant a new lease to a new tenant because you may not get the same level of rent in the new lease. Many considerations.
You've got lots of void periods, uncertainty. You know, there'll be some landlords that will definitely share the pain for a limited period if it means hanging on to their tenant. And one point we should also make clear, because it's often overlooked, is the rent arrears doesn't go away. It still sits in the background. And actually, there's another thing that occurred to me, Lina, as well, and it's slightly off topic, was break rights that are conditional on the payment of rents. That will be something that tenants are thinking about, exercising their contractual right to break. And they're going to have to be very careful if it's conditional on all rents, because they'll have to look back and work out when they've missed a payment. That's easy enough to do, but as you know, the interest can be defined as including the rent, and even
very often are.
Yeah, exactly. Yep, and there's been case law about that we know about, and it's easy to forget about interest, which accrues automatically, and you could easily see this being a fertile area for landlords to dispute break notices. So tenants need to be aware of that.
Indeed, and I think it's just one of these areas, again, careful consideration if you are intending to try to get out of your lease, whether you're a landlord or a tenant. It's worthwhile taking advice before either serving a notice or purporting to serve a notice.
Absolutely, it's definitely one of those areas that can trip people up. Okay, so here's the next question. If the stay on possession proceedings is lifted on 30th of June 2020, what kind of delay will parties be facing? And is there any way around this?
I am afraid I think they're going to be really long delays. Since the cuts in 2008 onwards, the courts have been overrun as it is. And the delays have been trying to get something done in central London has been difficult at the best of times. Now, with court staff having worked reduced hours, judges not having been in court buildings, not having had court files, everything has been incredibly slow moving. And with the backlog of lots of people issuing and going to issue, I regret to say I think it's going to be incredibly long delays as we come out of this.
Yeah, I agree with you. It could be a long delay.
I know they had a recruitment drive of deputy district judges. Hopefully can do a bit of box work when they go through it on paper.
Okay.
But I think there's going to be months of delay.
Yeah,
and also it's just going to be difficult to get listings because you don't have the court staff to actually set up the mechanism of the hearings.
Yeah, lots of focus on settlement, I think. Which is one of the other element to the question was any way around this. Things that spring to my mind. We said before, issue quickly, don't wait. If you're going to wait in the queue, get in the queue sooner rather than later. You're still going to be caught up in it, but the sooner you issue, further ahead in that queue you'll be.
I guess the other thing to consider is whether or not it's possible to do an injunction instead of possession claim.
Very good point.
If you're dealing with trespassers, because injunctions, you can seek an interim injunction, and these will be listed at short notice. The court always has slots available for injunctions. So that is a way of cutting the queue, so to speak, on the appropriate facts, of course. It's not a substitute for possession, but the court may be more amenable, particularly if there's something more urgent.
I think that's a really, really good point. I wonder if we're going to see, well, two things. I wonder if we're going to see an increase in injunctions. And I wonder whether, if there is to be an increase, whether that increase is going to be met with this sympathy we talked about at the start. Because we should just explain that the criteria for getting a possession order and an injunction are different. And you can get a possession order where you may not get an injunction, which is why you said it depends on the facts. But you wonder if this is a way around the delay, how the courts will react to that. I don't know what you think.
Absolutely, and it's important to remember that all injunctions are discretionary remedies, while a possession order, if you're entitled to a possession order, the court has got no jurisdiction not to grant it to you, whilst an injunction, the court never has to grant any injunctions.
Yeah, it's very good.
It's dealing with justice. So yes, I think the court is going to be astute to parties not misusing the ability to cut the line by seeking an injunction instead of possession. Yeah.
Oh well, we should wait and see. As you say, get advice. It's a big decision. The other thing that occurred to me, Lina, was of course once you get your possession order, and this is particularly an issue for certainly in residential possession cases. Enforcement. We deal with a lot of private rentals where enforcement takes place through the county court. That's because it's cheaper and it's more cost effective. But talking about cuts in 2008, it has become very clogged up, and it can take months sometimes for enforcement, during which period you're not getting any rent, of course. So there is the option to transfer it up to the High Court and have High Court enforcement, which tends to be quicker. It comes with the disadvantage that it is more expensive. But like we say, if they're not getting any rent, it could be the more cost-effective way of getting your property back, and another way of potentially getting around this inevitable delay, which is going to affect enforcement as well as listings.
It's something always to consider, Graham. I always look at it when you have a possession claim, whether it's worthwhile asking the court for an order to transfer up for enforcement. But not all judges are amenable to making these orders, and some judges see this as an abuse, particularly in the residential context, to transfer the case out of the county court into the High Court. So you can always ask, but you may not always get. Okay,
that's interesting. So is there a criteria, or is it's not an automatic? It's not right. Maybe it's.
When you're dealing with trespassers, you have an automatic right, and you don't need the county court permission. But when you're dealing with any previous tenant and not trespassers, you need the court permission.
Right, that's a good point. So there's not. Long story short, there's probably not a great deal you can do to get around this delay. You can certainly mitigate some of it, and in some cases you'll have options of circumventing it. But unfortunately, it's delay on top of delay, I think.
Yes, no, I agree. Unfortunately, I think that's what we are facing in the next few months. So, Graham, what impact do you think we're going to have on the market?
Again, one of those areas that I can't claim to have any real expertise in, and maybe we'll have to get somebody on who does, and they'll be able to answer this question. But I don't see how there's going to be anything other than a real downturn in the market generally. There's going to be lots of tenants, sadly, will fail. Lots of industries will be hurt worse than others. Excuse me. And I think it's inevitable that some businesses will fail, and a recession is likely to follow. We've seen in the last few years there's been a trend in rents finally going up since 2008, both in the commercial and in the residential sector. Whether that trend continues, it seems to be unlikely, but it could rebound quite quickly. You never know. There's also the fact that we've been working from home successfully in many cases for 3 months. So lots of businesses will be reconsidering the need for such office space. And again, whether there'll be closures of offices, sublettings, there may well be a general shrinkage in the office market. And then you have the high street, of course, that was already struggling before entering into this this period, and they'll be hit exceptionally hard as well. So it's difficult to think that there'll be anything other than a real downturn in the market generally, unfortunately.
I agree. I can't see this pandemic doing anything other than being incredibly bad news for landlords and the rent that they will be able to achieve on their properties.
Yeah.
That said, if you are a tenant, you might want to take advantage of this. I mean, one thing, if you are a tenant and your lease is about to expire or has expired, you might want to think about serving a Section 26 notice to ensure that you can get a new rent, a market rent. And you certainly want to think about whether you should be applying as a tenant for interim rent. Ordinarily, in a buoyant market, only landlords will apply for interim rent.
Yes.
But in these scenarios, you probably want to ask your surveyor about whether that makes sense in your case.
Yeah, great point, Lina. Really good point. I think, again, one of those areas is often overlooked, and that's because interim rent normally only benefits the landlord, because in a market that's trending upwards, interim rent is of little value to the tenant, and in a lease renewal context, quite often the landlords just want to keep quiet about it. Yeah, really interesting point. I'm not sure. I've not heard much about that in terms of inquiries from clients and surveyors. So perhaps maybe we should devote another entire podcast to that one, because I think it's a really
I could talk about interim rents for hours. Something else
interesting.
Something else I think worth noting, if you are in the 54 Act renewal proceedings, is again the Corona Act having made alterations to the 54 Act. So any tenant who has not been paying their rent between the 26th of March and the 30th of June, those rent arrears, whether they were incurred before this date, i.e. 26th of March, or during this period, cannot be taken into account when considering whether the tenant has persistently delayed in paying rent.
Yeah.
So another one of these slight tweaks to tenant protection, which is worthwhile keeping in mind.
Yeah, helpful for tenants. Yeah. Okay, Lina, final question. Do you anticipate any further legislative or court procedural intervention in this area?
Oh, such a difficult one to call. I think we'll have to wait and see. One can certainly see Section 51Z being extended, particularly if once the stay has been lifted, it causes mayhem within the courts.
Very good.
One could see the blanket provision on possession and obtaining possession by peaceful re-entry being extended on the Corona Act.
Yes.
Yeah, it's wait and see. I think what I think the government is looking at it very carefully, and we shall see. Watch this space. Yeah,
well, that's an interesting one you say about the peaceable re-entry under the Corona Act, because that was my concern for tenants. This tension between impatient landlords wanting the rent and defaulting tenants. that might be one, actually. That's one that maybe the market would benefit from, I suppose, because it is quite a draconian way of obtaining possession, and it's unfair for the tenant. I think a lot of these measures are about balancing the interests, and that might be one that helps redress the balance.
Particularly when many tenants are excluded from their premises by order of the government, that they're not allowed to be in the premises yet. They may not even know that they've been peacefully re-entered because they wouldn't be in the premises. I agree.
That's an
that
area.
might certainly be one.
The one thing that's come out of this as well, I mentioned the high street in the last question. One of the big complaints was the rates that high street premises, retail premises have to pay. And I've heard some discussions about whether that's going to be looked at going forward. Certainly, there'll need to be some adjustment for the last few months when they've not been there. So maybe that's another area where the government will step in to assist the tenants. Like you say, very hard to say, but anything's possible, and you wouldn't rule it out.
Absolutely. I think watch this space. The government seems to come up with numerous different ways of trying to protect tenants' positions, and they may well extend them or come up with new ones.
Right. Okay. Well, thank you for that, Lina. Hopefully people found that interesting and will want to tune in again for the next episode. Should we describe what we're doing and what we propose to do for the next one?
Absolutely. So next time we're talking about interim rents under the 1954 Act, which is one of my favourite topics. Good. So I'll be looking forward to that. Yep,
me too. And hopefully we'll see if we can get a valuer on or somebody just to can talk more about the market trends. We'll see what we can do.
Looking forward to it.
Great stuff. Thank you, Lina. Take care.